The matter of the people of the state of Michigan versus Leroy Blevins, 25-03705. Ms. Harrison.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Blevins, who is standing to my right.
Mr. Blevins was scheduled today for domestic violence pre-trial. However, over the weekend, or late last week, the court received a request for a complaint of violation and conditional release of violation.
That's a huge development. A bond violation means the defendant may have broken the court's direct instructions while waiting for trial. Judges take this extremely seriously because those conditions are designed to protect victims and prevent further incidents.
Of conditional release from custody, to which the court ordered Mr. Blevins' bond revoked pending a hearing. And then it looks like after I ordered that, I then received a emergency motion to revoke the bond from the prosecutor's office based on that same report. The allegations is that the defendant violated the bond conditions that was set by Magistrate Milmore back on December 12th by having contact with the protected party that he was not supposed to be within 2,000 feet of.
And this is where the allegations become even more serious. The court isn't just hearing about contact, it's hearing about possible abusive actions toward a protected child, his own grandson. That's exactly the type of situation bond restrictions are meant to prevent.
And the allegations is not that he was just present, but that he engaged in assaultive or abusive actions toward that child being his grandson, and that there is now, I think, some involvement from CPS. Is that accurate?
That is correct. And I did last week sign a stipulated protective order with APA Del Vero. I am still waiting on that to be sent over to me, but I anticipate it will be coming shortly. Okay. The records from that.
The court is going to advise you that based on the allegations that you violated your bond, you do have the right to have a contested hearing on the bond violation. You have the right to be represented by your attorney at that bond violation hearing. And if you're found to be in violation.
Notice how carefully the judge explains the defendant's rights here. Even when someone is accused of violating bond, the court still has to ensure due process. But make no mistake, if the violation is proven, it can mean jail time before the trial even starts.
Of your bond, you're facing contempt of court. That's punishable by up to 93 days in jail. Do you understand that?
Yes, I just got informed that, yeah.
I'm sorry?
I just got informed that.
Okay. You also could have your bond revoked for violation of your bond, and you could be sitting in jail pending the outcome of this case. Do you understand that?
Yes,
the court will enter a not guilty plea at this time. My understanding is that you were residing at 430 North Larch. Is that correct?
I was before this, Your Honor. Before I went back to, I'm staying.
And right here, the conversation takes a risky turn. The defendant says he's living at 909 Bel Air, but remember, he's not supposed to be within 2,000 feet of the protected party. If those locations are close, that single statement could become a huge problem.
You staying with your son? Where's that?
That's 909 Bel Air.
The
Address.
alleged incident on Bel Air at 1001 Bel Air. How is it that you get a bond that says you can't be within 2,000 feet, and then you go to 909 Bel Air? Is that within 2,000 feet of each other?
Your Honor, I'm going to advise my client to not say anything more here if there's a hearing on this issue.
There's not a hearing on his address. I asked him what his address was. He told me it was 909 Bel Air.
I understand.
So I want to know, how are you living at 909 Bel Air?
And that answer might have sealed the situation. Saying it's probably within 2,000 feet basically confirms the judge's concern. You can even see why the defense attorney immediately tells him to stop talking, because sometimes a few words in court can completely change the outcome.
Well,
Is that within 2,000? I have to address his bond at this point. Is that within 2,000 feet of 1001 Bel Air?
yes, probably, yes. Your Honor.
Okay, I'm not familiar with how the house, is it an apartment complex?
It's a townhouse.
It's a townhouse. Okay, they're not on the same street?
Yes,
Those two houses are on the same street?
yes.
And the alleged incident took place at 9:09, the alleged bond violation that is, took place at 9:09, or I'm asking the prosecutor. 9:19,
919, Your Honor.
is that the actual address, 9:19?
Yes.
919 Bel Air, which is not where the victim lives, correct?
No.
I'm asking the prosecutor.
Allow me 1 second, Your Honor. Your Honor, I have the address listed as 919.
For the victim?
Yes, and I believe it's because they're in the custody of grandmother.
Your Honor,
Well, I
I'm
thought
not-
that was the son's was 919, and it looks like the defendant's original address was 1001 Bel Air.
That's.
Nope, that's not to you. Your Honor, if I may. The report indicates a different address for the complaining witness.
It's in 70 feet of each other.
001 Bel Air
Is the victim's address?
is the address that we have listed for the defendant.
Okay. That's the address we had listed for the defendant too. However, that was his address, I believe, at the time of the original. Okay, actually, the location of the offense took place at 919. The underlying offense took place at 919. Let's see.
I'm not interested in stating the actual address on the record, but the report indicates a different address.
Your Honor, I see in the count, it's listed as 919 as being the location of the incident.
Yeah, I see 919 as the location of the alleged underlying incident and the location of the bond violation.
December 12th, yes.
So how is it that he's telling me that he lives there now? I was going to put him on GPS tether, but now I gotta just revoke his bond.
And there's the decision. The judge decides the situation is too risky and revokes the bond completely, meaning the defendant will stay in custody until the next hearing. In courtroom terms, that's a major setback, and it shows how seriously courts treat violations of protective orders. Balance scale.
Your bonds were, you're remanded until the time of the hearing.
So, look, this is what I'm gonna- The different addresses provided.
What's the hearing here?
This isn't, I'm not just saying on the record, but that is the report provided in.
Yeah, it says,
provided
it
in the
says
report.
1001 Bel Air is directly next door. That's what it says in the affidavit of probable cause. So, let's see here. I need to set this, are you looking for, you're looking for a trial date on this?
Hearing date and a final pretrial, I think, Your Honor. There
It's
may be
a minor, so I'm
global-
not gonna do a final pretrial.
Then I suppose a second pretrial, Your Honor. My purpose in asking is there is another case before the circuit court that we may be looking at a global resolution with. So I don't want to go straight to a jury trial date if that is possible.
Okay, connected or related to this?
No, Your Honor, just another case with the prosecutors, with the state prosecutor's office. I admit I have limited understanding of what that case is. I know that it exists, but as far as I'm aware, it is not related at all.
It's unrelated, Your Honor.
Okay,
That is currently set for a circuit court hearing on February 18th.
we'll set up a pretrial and a PA 53 after February 18th.
We can do February 24th at 10.
February 24th at 10. Will be true notice to appear any additional matters for the record.
Not at this time, no.
You're all set.
The report is retained.